The early chapters of the Rehnquist book very nicely summarize the first several decades of the court's history, including some of the initial cases of consequence for the nation. One helpful element of this historical narrative is that just two individuals served as Chief Justice during much of this period. John Marshall wasn't the very first official Chief Justice, but he was certainly the first one to put his mark on the court, and he ended up serving an incredible 34 years. And he was followed by Roger Taney, who served almost as long right up until the Civil War era. So I'll be highlighting some points and cases from these two court eras as the Rehnquist book discusses them. And I hope these slides and some of these comments really help you track with some of the historical material that's presented in this volume. Perhaps the most famous early case, and certainly one of major import that you need to remember, is the Marbury versus Madison case, which was really one of the first cases decided right after John Marshall had been appointed as Chief Justice. Now, you may remember from the Jones book that the first presidential election that was really fiercely partisan was the 1800 election between John Adams and Thomas Jefferson. Adams represented the Federalist Party and Jefferson represented the Democratic-Republican Party. And remember, at the time, both of these parties were relatively new creations in American politics. Jefferson ended up winning that very, very contentious election. And in the weeks just before Adams and his Federalist Party members handed over control of the presidency to Jefferson's party, Congress, which was controlled by the Federalists, created a whole host of new federal judgeships, and Adams set about the process immediately of appointing Federalists to those positions. Now, Marbury was appointed officially the night before Adams left office. He was a so-called midnight judge. When Jefferson's people got to the White House and discovered the Marbury appointment papers, they realized that those papers hadn't been delivered to him yet. And so Jefferson's Secretary of State, James Madison, just decided not to deliver the papers at all. And Marbury sued, claiming that the Jefferson administration ought to be compelled by the court to hand over the appointment document. And so that's the matter that ended up in front of the Supreme Court. Now, this, of course, brought to the fore the question that really wasn't answered very well in the Constitution. Namely, could the judicial branch of government compel either one of the other two branches to behave in a certain way? And if so, how was that supposed to happen, given that it didn't have any obvious enforcement power? So Marshall actually rendered an interesting opinion. He ruled on the one hand that Madison should have handed over the commission papers to Marbury, as they had been drawn up legitimately by the previous administration. On the other hand, he also ruled that one of the sections of the Judiciary Act of 1789, that was the legislation that created some of these positions, was unconstitutional because it gave powers to the Supreme Court that weren't explicitly allowed by Article 3 of the Constitution. So what this decision did, of course, was establish the precedent that the court could determine whether an act of Congress was actually in accordance with the Constitution. And this has been a key role that the court has played ever since. As you can see by this next slide, John Marshall was actually Chief Justice for 34 years, from 1801 to 1835. So during this time, many of the court decisions helped establish some of the ground rules for how the states would operate and how the national government would function with regard to the states. So some of the cases to watch for in Rehnquist include Gibbons v. Ogden, which gave the federal government some authority under the Commerce Clause to override some state decisions involving interstate commerce issues. Others to watch for include McCulloch v. Maryland, which involved the ability of the federal government to obligate state governments to take part in the national banking system, and the Dartmouth College case, which helped determine the nature of contracts in the United States, and the ability of either the states or the federal government to insert themselves in privately run organizations, such as independent colleges and universities. Now, Chief Justice Marshall was replaced in 1835 by Roger Taney of Maryland. And Taney served in that role for another 29 years and hung on really till the latter part of the Civil War period. Now, as the slide here says, for much of its time, the court left the Marshall precedents in place, but qualified them in various ways, especially with regard to interstate commerce. So the Charles River Bridge and Cooley v. Board of Wardens cases, for example, really helped define the role of regulating businesses that crossed state lines. Now, the case that Roger Taney is actually remembered for throughout American history was the Dred Scott case from 1857. That was very late in his tenure as Chief Justice. Now, I mentioned that Taney was from Maryland. That was a pro-slavery state, and for various reasons of geography and the Court of Appeals system, the Supreme Court at the time had a pro-Southern majority that tilted it heavily in the direction of supporting slavery. Now, one of the weaknesses of the Rehnquist book is that he does not provide much background in terms of the growth of slavery in the decades before the Civil War, but that's nevertheless an important part of the story and provides some context for this particular case. So here are just a few things to keep in mind. The northern states had mostly eliminated slavery by the time the Constitution was drafted, but the southern states had agriculture-based economic systems that still relied pretty heavily on slaves. So as we discussed earlier, slavery was allowed under this Constitution in 1787, although the international trade in slaves was to be ended within 20 years. Now, arguably, most of the founders expected in 1787 that slavery would eventually die out in the South and that eventually a free labor system like in the North would replace the slavery system. But the development of the cotton gin in the mid-1790s eventually made cotton a hugely profitable crop to Southern plantation farmers. And so they built a kind of regional empire in the Southeast based on slave labor. Now, by 1820, the westward expansion of the United States was all tied up in the slavery issue. Northerners wanted slavery limited to the original Southern states, whereas Southerners wanted to see it extended wherever the nation expanded. If you remember from your high school U.S. history, the Missouri Compromise established a line above which slavery was not to be allowed and below which it was to be allowed. But by the 1850s, the Missouri Compromise really fell apart under Southern pressure to expand slavery. And the Kansas-Nebraska Act of 1854 allowed the Western territories themselves to decide whether to allow slavery in or not. And this whole thing upset the political balance around the issue and arguably led to the Civil War. Now, the Dred Scott decision itself represented the Southerner Roger Taney's own attempt to kind of settle the issue once and for all. Now, I've read this case myself, and it's one of the most shocking documents, to my mind, in all of U.S. history. Taney, in his opinion for the court, just vehemently rejected the notion that slaves could ever or should ever be given any rights whatsoever under the Constitution. He also argued that the Missouri Compromise itself, which had been law for 35 years or so, 34 years, was unconstitutional because he said the federal government didn't have authority over the states or the territories with regard to slavery. So it was wrong of Congress to try to prevent states north of a certain line from allowing slavery either in the past or in the future. Now, Rehnquist says that Taney's willingness to toss out Congress's ongoing attempts to reach political compromise over the slavery issue represented a cavalier attitude by the court toward the Constitution that really harmed its reputation for the next several decades. So the Dred Scott decision really laid the groundwork for the Civil War, and it helped fragment national politics into 4 separate regional parties, and this in turn enabled Abraham Lincoln to win the election of 1860 with only electoral support from the North. So fear of the North's plans to limit the expansion of slavery in the wake of Lincoln's election was what led the Southern states to secede and attempt to form a separate nation.